going over the Islamic aspect of creating a last will and testament. And actually, we're overall going to go over the laws of inheritance and how those work. Um, of course, there is also in BC, you have to keep in mind that there are also legal requirements for the completion of a will, which I believe you will be hearing from a lawyer at some point in the future, inshallah. So these are the Islamic requirements, and I have a presentation that should take about half an hour to 40 minutes, inshallah. And after that, I can answer any questions that you have. So I have, is everybody able to see my screen?
Yes, I can.
Okay, so this is just a very brief presentation that we have regarding the Islamic laws of inheritance. The first thing that we have to remember is when you are alive, it is permissible for you to do anything that you would like with your money, with the money that Allah subhanahu wa ta'ala has blessed you with. And the only condition, of course, is that whatever you do should not be haram. And if you have minor children, then it is a requirement for you to be just with your between your children. If someone has more than one spouse, it is a requirement for them to be just between their wives. But apart from these general things that most everyone knows, you can pretty much do whatever you want lawfully with your money. So this the reason I mention this at this point is because a lot of people have this question that when they are still alive, is it necessary for them to if they wish to distribute their assets and their estate during their lifetime, do they have to follow the same laws of inheritance? And the answer is no, that you know, for whatever reason, if you wish to give one child more, one child less, as long as they are not minor children, then this is something that is permissible to do. And for example, you know, sometimes people have multiple children. Some of them may be more well off than others. So if you wish to give one of your children something during your lifetime to help them out, then this is fine. This is permissible for you to do. So the entire focus of this discussion that we are having is what happens with the remaining estate after you actually pass away. So once someone passes away, immediately everything that they own, so all property, all assets that they own, become part of their estate. And the first thing that happens when someone passes away is from their own estate, if they have not already made funeral arrangements, then we take the necessary expenses for burial arrangements from their estate, and those arrangements are made, even if this means that there is nothing left behind for the heirs. So that's number one. Number two is any debt that this person owed to anyone is to be paid from their estate. Again, even if this means that everything that all of their estate is encompassed in this debt and all of it is spent, then this debt is still cleared. It's a priority. And number three, so after the burial expenses and the debt, whatever is left behind is split into three. From 1/3 of that portion, it is permissible to make a wasiyah. A wasiyah is a bequeathal. So this means it is permissible for you to dedicate this 1/3 of your estate to anyone or any cause that you wish. You can give it to the masjid, you can give it to an individual. The only two conditions on this wasiyah is, number one, you cannot make wasiyah for someone who already has a share of of your inheritance. So, for example, you can't give that extra 1/3 to your son, because this defeats the purpose of the laws of inheritance. So, if you are going to go ahead and give extra to one of your heirs, then this defeats the purpose of the fixed shares that Allah subhanahu wa ta'ala has legislated. So you cannot make a wasiyah for someone who is already inheriting from you. It is permissible to make a wasiyah for those who do not inherit from you. For example, your grandchildren do not inherit from you, but if you wish to give them something, then it is permissible to make this wasiyah. There are others. So if you have children of your own, if you have male children of your own, then your brothers and sisters do not inherit. If you wish to give them something, then it is permissible to make this wasiyah. And the second condition is that whatever wasiyah you make, this cannot be for something that is impermissible, of course. So any wasiyah for something that is haram, it will not be carried out. The next is there are three types of heirs as far as the Islamic law of inheritance is concerned. Now, I am aware of the fact that I am speaking to the Kerala Muslim Association of BC. So the majority of you, I'm assuming, are Shafi'i in your school of fiqh. However, there are no major differences of opinion in terms of the distribution of inheritance. There are some minor differences of opinion that usually don't apply to the majority of the cases, so we won't be discussing those today. But overall, this is pretty straightforward. There are no real differences of opinion in the distribution of the estate. So that's why I'm not mentioning any differences, because there aren't many there. So the first type of heir is a sharer. So a sharer is what we would call dhawil furud in Arabic. What this means is that these are those individuals that Allah subhanahu wa ta'ala has legislated their portion of the estate. So these are those that you find in Surah An-Nisa, for example, and elsewhere in the Quran, where Allah subhanahu wa ta'ala has already designated a fixed amount that they will receive in the inheritance. Number two are what we would call residuaries. So a residuary is that individual who apart from their fixed share and the fixed amount that they receive, they also, as the name suggests, the residual amount. So whatever is left behind after the distribution of the estate will also be given to this person. So, for example, a father is a residuary in certain circumstances. So he will get his fixed share of the estate. And after everyone else gets their share, if there is anything left behind, that will also be given to the father. And number three are, in English, we call them distant kindred relatives or asabat. These are those individuals who don't have an automatic right to inheritance, but in certain circumstances, they are given a share of the inheritance. So it's for lack of time, and it's usually not something that you can understand in a single session, but I will mention who these individuals are. So the Dhawil Furud, these are those individuals that are mentioned in the Quran that have a fixed share of the inheritance. Sorry. So a fixed share of the inheritance means that Allah subhanahu wa ta'ala has legislated what these individuals they will receive from the inheritance. So in those verses where Allah subhanahu wa ta'ala says يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلث ما ترك وإن كانت واحدة فلها النصف. So all of these fractions are those that Allah subhanahu wa ta'ala has legislated, and their names are mentioned, or their relationships are mentioned in the Quran, and their fixed shares. So these are all of those individuals. And a uterine brother, as the name suggests, is a brother, two brothers that share a mother but whose fathers are different, and a consanguine sister is the opposite. So they would share a father and their mothers are different. A residuary, so there are three different types of residuaries. So one is a residuary in their own right. So this is people like the father and the brother and the son. So they are always residual heirs. So in most circumstances, so whatever is left behind after everyone else gets their share will also be given to these individuals if there is something left behind. Quite often, there is nothing left behind, so there is nothing extra that they will get. But if there is something left behind, then they will get this. Residuaries in another's right, I'll explain that in a moment. And the third is together with another. So residuaries in their own right are son, grandson, father, grandfather, brother, brother's son. So means your nephew. So the reason we don't say nephew is because in English, of course, nephew also means your sister's son, but in this case, it's only your brother's son. And number four is your uncle. So uncle means uncle. So that's either your father's real brother or your father's half brother, means that they share a father, even if their mothers may be different. And your uncle's son, so real and consanguine. And residuaries in another's, and I don't expect you to remember all of this, by the way. I'm just going through this very quickly just to give you a little bit of an understanding of what what goes into the laws of inheritance and how the shares are decided. So residuaries in another's rights are those female relatives who are entitled to fixed shares but become residuaries when together with their brothers. So, for example, a daughter is entitled to a fixed share, but when she has a brother, then she becomes a residuary, means that the residue of the residual estate will be shared between the brother and sister at a ratio of 2 to 1. So for every share the sister receives, her brother will receive 2. So this is apart from her fixed share. So whatever she is already getting, if there's something left behind after everyone else gets their share, then this is how it will be divided between her and her brother. So residuaries in another's right are always female relatives that are joined by a male relative that convert them into this residual status. So these are the four individuals that become residuaries in another's right. And residuaries together with another are those women who are sharers, who have a fixed share, but are converted to residuaries in the presence of other female sharers. For example, a real sister, when in the presence of the daughter and granddaughter, will become a residuary. So if someone does not have male children, then the other female members of the family that are not one's own children become residuaries together with the real the female children of the individual who has passed away. So again, you don't have to remember all of this, but this is just gives you an idea of how the laws of inheritance are dictated by Allah subhanahu wa ta'ala inside the Quran, and in some cases in the hadith of the Prophet sallallahu alaihi wasallam. So I'm just giving you a few examples here of potential circumstances that this is the line in the bottom over here, or the top. Beneath this line are the heirs that are present when someone passes away. Does anybody want to take a guess what happens here? Who gets what in this circumstance? So maybe some of you may be familiar with some of the laws of inheritance and how they work. So I guess the best way would be to show your hands, but or Brother Jasmine, do you want to monitor this?
Yeah, I will monitor. I'm just waiting for someone to raise their hands.
Okay. Okay, so let's start with the wife. What do you think that inside the Quran, Allah subhanahu wa ta'ala, when mentioning the wife, Allah says that وَلَهُنَّ الرُّبُعُ مِمَّا تَرَكْتُمْ إِن لَّمْ يَكُن لَّكُمْ وَلَدٌ فَإِن كَانَ لَكُمْ وَلَدٌ فَلَهُنَّ الثُّمُنُ مِمَّا تَرَكْتُمْ, which means that For them means for your wives, they will get 1/4 if you do not have children that you leave behind. And if you do have children that you leave behind, she will get 1/8. So in this circumstance, what do you think she should get? I see someone has.
Oh, it's me.
Okay. So in this circumstance, she would get the 1/8. Then you actually I can show you these over here. So the 1/8. Now the daughter gets half. The mother, so this is the mother of the deceased. So all of these relationships are in relation to the person who has passed away. The mother will get 1/6. This is how Allah subhanahu wa ta'ala mentions it in the Quran. That in the presence of children, she will get 1/6. The grandson in this case over here is a residuary, means that he will get whatever is left behind after all of these. Now, one thing that I forgot to mention over here, that the reason that I mentioned these shares in fractions and not in percentages is because this is how they are mentioned in the Quran. So it is possible to distribute this according to percentage instead of fractions, but in most of our books of fiqh, they are mentioned as fractions because that is how Allah subhanahu wa ta'ala mentioned them inside the Quran as well. So half, 1/4, 1/6, 1/3, these are the fractions that are mentioned inside the Quran. So of course, so when we are dividing fractions, we would divide them according to the common denominator. In this case, that would be 24. So the way that this would work is out of the 24 shares, the wife would get 3, the daughter would get 12, the mother would get 4, and the grandson would get 5. And the maternal grandmother is B, stands for blocked. So in the presence of certain relatives, certain other relatives, they don't receive a share, they are blocked. So that is why she doesn't receive a share over here, and she doesn't get anything. So in this circumstance, this is how we would divide this particular estate. There are a few other examples. So wife, daughter, mother, father, and paternal grandmother. So we should know by now what the wife gets.
1/8.
Yes. And the daughter? So the daughter still gets a half. The mother still gets a 1/6 because the deceased left behind children. The father gets 1/6, the same as the mother, because from the share of this would be the deceased son that has left this behind. He would get 1/6, plus he would get whatever is left behind. So remember, we said that residuary, the father is considered a residual heir. So if there is anything left behind after the distribution of this estate, he would get that. And again, the paternal grandmother does not get a share even in this circumstance. She would be blocked from her share. The common denominator here is also 24, and this is how the estate would be distributed. So like before, the wife would get 3 shares, the daughter would get 12, the mother 4, the father 4, and this would leave us with an extra share, which because the father is a residual heir, he would get that share as well. And again, you don't have to remember all of this. I'm just giving you some common scenarios. Usually it's the best idea for when preparing your estate is just to visit an imam or someone who can detail this to you. They would usually just ask you for a list of people in your family, and would give you different scenarios depending on who passes away first. So these are some others. So the husband, son, daughter, and father. So the husband, so this is the wife who has passed away. So the husband gets 1/4 because there are children. If there were no children, the husband would get half. The son and daughter, they are residuaries together with each other. So their share would be whatever is left behind after the other two heirs get their share would be shared between the two sons and the daughter at a ratio of 2 to 1. So over here, the common denominator is actually 12, and this is how the shares would be distributed. So each son would get 2.8 shares, and the daughters would get 1.4. And the one on the bottom over here, the wife, the mother, and the father. So the wife gets a fixed share because there are no children. So if there were children, she would get 1/8. Because there are no children over here, she gets 1/4. The mother gets 1/3 of the leftover, and the father is a residual heir. These two, very quickly, this is the husband, two daughters, brother and sister. So this is how we would distribute their estate. The husband gets 1/4 because there are children. There are two daughters, a brother and a sister. Now, the reason the brother and sister are getting a share over here is actually because there are no male children. So if she had male children, so this is the first example we're talking about. If the sister who passed away, if she had male children, then the brother and sister, her brother and sister, would not actually inherit from her. So husband, son, daughter, mother, father. So the son and daughter are residuaries. The husband gets 1/4 because there are children that the deceased has left behind. The mother and father each get 1/6. At any one time, there can only be one category of residual heirs. Otherwise, it wouldn't make sense. So although the father is a residual heir, but not in the presence of a son. So the son would get preference over here. So the 12 shares would be shared in this manner. We won't talk about this right now because it is so this is actually in certain circumstances it would not be possible to find a common denominator. So what happens in that case? The reason we won't talk about that is because it's not a very common occurrence. So it's needlessly confusing at times. So this is basically what happens when how we distribute the estate. Apart from the distribution of the estate, the other important factor to consider when preparing your will is if you have minor children, then what happens to those children once you pass away. So of course, if either one of you passes away, the husband passes away or the wife passes away, then the remaining parent would take custody of the children and would take care of them. If Allah forbid, if both husband and wife pass away at the same time for in a car accident or something like this, then minor children, it needs to be decided who is going to take care of them. Now, there is no hard and fast rule as to who must take care of the children. It's whatever is in the best interest of the children. So it's up to the husband and wife to decide during their lifetime what would be in the best interest of their children, and accordingly put that in their wills. The next important thing that you need to decide when you are creating your will is end of life planning. So this is not in your actual will, but it's prepared at the same time. And the lawyers, when you have a presentation with them, I'm sure they will give you more details on this. But this is basically what you would like to see happen if you towards the end of your life, if you are in a position where you require medical treatment, to what extent would you like to have that treatment? So the reason for this, so the Islamic perspective on this is that it is necessary for us to do everything within our means to help someone who is sick. However, if there comes a time during the course of treatment where there is no longer a hope of recovery for someone, then the question that is asked is, would you like to withdraw end-of-life care? Means that would you like to pull the plug, or would you like to withdraw the assistance of machines that help someone breathe or help their heart beat or things like this? So the ruling regarding that is, if this is the opinion of the doctors that there is nothing else they can do for this person, and if there is no other treatment option that is available, there's nothing that they can do for this person, then it is permissible to withdraw care at the end of life. So it's not that you are actively assisting someone to take their life. It's rather, it's passive. There's no longer anything that can be done at this time. So to withdraw the assistance of machines and any sort of mechanical intervention is something that is permissible. So these sorts of dictates, they are usually discussed in advance, and it relieves the family members of a lot of pressure if you prepare your wishes in advance, that if such and such were to happen to me, then I would like this to happen. So I would not like to be put on life support, or I would not like to go on a ventilator, or I would like to go on a ventilator, or whatever your wishes are. So that's something that's also needs to be prepared. And the final document that you need to prepare is, it relates to financial matters, that if you are in a position at some point in your life that you are incapable of making your own financial decisions, then who is going to make those decisions on your behalf? So a power of attorney relates to financial matters, so not matters related to health, that's a different document, rather financial matters. So things like, who can administer your estate, who can access your bank accounts, who can do what. So that's also a document that is prepared. And again, when you hear from the lawyers, they will tell you more about this. So these are Islamically some of the things that you need to consider when preparing your estate, and I would be happy to take your questions now, inshallah. I'm not sure how you normally do questions. You can either write them in the chat, or if you're comfortable to speak in the recording, please feel free to do so.
Yes, yeah, we usually do a mixture of both. Some, people who are comfortable speaking, they do speak, and so please feel free to ask any questions you may have or any comments. Omar?
Usually in every group we have a few famous people that love to ask questions. Is there any such person here in this group?
I think there are, but they're keeping silent for now for some reason. Alhamdulillah. I have a question, if I can. So what happens if I do not prepare the will? If, and then something happens.
Typically, what would happen if you don't prepare your will is so if you leave a surviving spouse, she would just get everything, and if you don't, then what your next if you have children, your estate would just be split equally between them. So there is a common misconception in our immigrant community that if you don't leave behind a will, then the government takes all of your assets. That's not true. That's
Got it. But if both parents pass away, in that case, does it go to the court? And
I'm not sure what exactly would happen in that circumstance. That's probably a better question for the lawyers.
Got it. Okay.
But it's not true that it would just be like taken.
Mm-hmm.
I would like to add one point there. If you don't have a will in place, then basically that will go to the estate. Then government won't take the property, but they will appoint a person. Then the process will be much longer to get the
Yes.
beneficiaries than the normal procedure.
Correct. So you actually have a lot of flexibility in terms of what you would want to happen with your estate. The only challenge that most people could potentially have is if somebody has a claim to their estate. Now, usually those claims, unless they're not honored, but they needlessly prolong the process. So like if some random person comes and says, one day I met this brother at the masjid and he told me that after he dies, I can have his house. I probably won't get it, but I will needlessly prolong the process for the family. So that's one reason the will is very important. The second reason the will is important is in BC, the courts have what we call corrective, or not what we call, what they call corrective powers. So if one of your heirs claims that they have been wronged in the distribution of the estate, then if the court deems their claim to be valid, then they could potentially correct your injustice, right? So that's why it's important to have, depending on the complexity of your circumstance, it's important to have your will drafted properly, so that if there is a potential challenge, then that explanation already exists within your will as to why you distributed your estate the way that you did. I see a question inside the chat. It said, if we decide to give custody of our kids to a relative friend here, can they then decide to give the custody to kids' grandparents or other relatives in home country? So yes, they can. Again, I'm not a lawyer, but this is possible. However, there are, once legal custody passes on from one person to the other, in effect, that person becomes the person who decides in all matters related to the children. So it's, yes, they could potentially do this if they wanted to, or if you wanted to. Sometimes it's difficult for a person, depending on how complicated your situation is, to give custody in the will to someone who doesn't live in the country. So you would have to consult the lawyers to see if that is an option. So for example, and this is a real concern for many people because they are here alone. They don't have extended family in the country. So if something were to happen to them, then you would need to consult with the lawyers whether or not it is, how feasible it is to give custody of the children to someone who is not a resident of Canada.
Would be great if you can share more information about this, probably clarification if you know. As far as I know, if you don't have will in place and if both the parents passed away, the kids' custody will go to foster care.
No, not necessarily. So if there is if nobody is willing to step up and take custody of the children, that does happen, unfortunately. But if you have other relatives so this has to be actual relatives, so not just family friends, but people. So if you have a brother, a sister, or someone else who lives in Canada, if they are willing to take the children, then they will be given preference. However, it's a very complicated thing when they decide, when you haven't left the instructions, then sometimes it becomes complicated that, if the system decides that the person, the next of kin does not have the resources to take care of this child, this could potentially set you up for trouble. So it's best that you actually put this in writing inside your will, who you would like to have take custody of your children.
Yeah, mainly for the immigrant community, especially for this Kerala community, the 95% of us are just themselves, no relatives here.
Yes. So it's you don't have to give custody of your children to one of your relatives, like someone asked earlier. It is possible to give custody of your children to someone else, so long as they agree to this. So that is one thing that you can do to avoid the legal troubles of giving custody to someone outside of the country, and then that person could potentially do this for you if they were aware of your wishes.
Okay, I guess the conclusion of that discussion is it's definitely better to have a will in place.
Yes, yes, of course.
Okay. One quick clarification regarding the split that was mentioned earlier, how we want to split the estate, right? If I am sharing my estate or property with my spouse already, right? Maybe we have joint ownership.
Yeah.
In that case, also is the same split applicable, or does it change?
So most people, for example, home ownership is usually joint. So any assets that you jointly own 50-50, your spouse already owns 50% of that. So your share is only 50%. So whatever your estate would only include, so for example, let's just say the home. So if you own a home jointly with your wife or with your husband, then you only technically, in the eyes of the Sharia, you own 50% of that home. So it's only 50% of the home that is going to be distributed as part of your estate. The other 50%, your wife or your husband already owns.
Correct. So that split that you showed will be of the 50% that, for example, I own.
Correct.
Right?
So it's
only within that also it will go 1/8 to the spouse, 1/4 to the spouse, based on whether you have kids.
Yeah, so she or he will get will get a share of your 50% that you owned, but the distribution will only be taking part in the 50%. Sometimes it's a good idea that this is usually the case with homes, because most people, the most valuable thing that they own is their home, if they own their home. So and they don't usually have like that amount of cash lying around to sort of buy give people their share in cash instead of in the value of the home. So it's usually a good idea to have an agreement, especially with the children, that you will get your share of the home, but so long as your mother or your father are alive, whoever is second to die, you will allow them to live inside that home. You won't force them to sell it and to give you your share. And this, depending on how how difficult you think your children may or may not be, you might want to get this in writing as well. There is a legal aspect coming in, and there are also financial planners who do will and estate planning. Who would be the best to reach out for will and estate planning? So there are definitely two people that you need to talk to. So one is to obtain the Islamic point of view. You would just speak to an imam or somebody who is well versed in that area. And the second is, most people, it's best for them to have a lawyer prepare their will. Although in BC, a notary public can also prepare your will, but it's safest for a lawyer to do this. And then, depending on the complexity of your financial situation, you may also want to talk to an accountant. So two definitely, and some people would need three. And the reason you may want to talk to an accountant is they may advise you on how to restructure some of your assets and your accounts to make the process more efficient in terms of just time and in terms of tax. So that's why. Some people, their situation is not very complicated, but if you own a home or more than one home, if you have investment portfolios, if you have, if you have a number of different things, then it may be a good idea to talk to an accountant as well, who may advise you to restructure some of these things to make this process more efficient. Is there a website that helps us with this process without contacting a lawyer, and will that be valid? So any will that is written by you is valid. It's the reason we advise contacting the lawyer is just to make sure that it's in the event that somebody challenges this will, then it's sound from a legal perspective. Otherwise, if nobody really challenges your will, you can write it down on a piece of paper, and if the that's okay, but it's just to safeguard, because at the end of the day, you want whatever you worked hard for to actually pass on to your children and to your family members, and not just be stuck somewhere for a prolonged period of time without them having access to it. So that's the reason we generally advise doing this with a lawyer. And lawyers, it really depends on how complicated your situation is. So I don't know exactly what every lawyer charges, but in terms of my experience, for simple wills, simple means that you don't have like multiple investment properties and you're not like a millionaire. You are an average person that like most people. Their straightforward wills can be prepared for under $1,000, and if somebody's situation is very, very complicated, then of course that would be more, but for most people that is what you are looking at.
To simplify, probably we can just execute, appoint, execute some of a friend as an executor, and simply add, I would like to distribute my estate as per Islamic Sharia. Will that work?
No, you would have to be a little bit more specific than that, because the court has no idea what the Islamic Sharia is. If your executor is aware of this, then yes. So it would really depend on the size of your estate, to be honest. So estates under, I believe it's under 25,000 or something like this, are far more simple, and the court doesn't really get is not really concerned with those. But if you own your home, for example, then that is you would want to have a little bit more of a detailed will. I think someone is raising their hand.
Yeah, it's me. I think following up on Brother Nafid's question there, I think he was mainly talking about the situation where the will is not challenged. Like if there's no trouble, if nobody has a problem with the will, then in that case, just writing on a piece of paper that, hey, this is my executor, these are the two witnesses, and I asked the executor to distribute according to the Islamic Sharia.
I think that should be fine. You can double check with when you have your session with the lawyer, but that should be okay.
Okay.
Also, one last question. Sorry, I'm asking too many. Yeah, so being in Canada, is it a good idea to add a funeral condition in the will? I want to get buried in Islamic funeral things.
Yes. So most of the time, if you are Muslim and your family and your friends, they know this, and they will take care of this, but there is no harm in putting it inside the will. And a lot of people actually, so if they know that they're living in BC and they don't plan on leaving here, they actually specifically name the BC Muslim Association as the organization that will carry out the funeral procedure.
Jazakumullah khairan.
Hey, on that question that Zuni asked about the website, we do not have a specific website for BC or anything like that, but there are a couple of websites that helps in the Ontario region. There is a website, I think Manzil just bought them, but they only is applicable in Ontario. There are some legal stuff there, but there are a lot of templates that's available which you could use and then get a PDF out of it, and then you can use that as your will. But all this without now all this like Imam Yahya mentioned, right? This will be valid as long as there are no problems with it. There are nobody raises any questions about it later.
So I have that I can share with you the BC Muslim Association's will kit. So it's not like a fill in the blanks kind of template, but it is there. I'm just trying to find it, and I will send it to you just now in the chat.
That'll be very helpful.
Is there any other questions that?
From an Islamic perspective, is preparing my will mandatory? Is it wajib?
If you have anything to leave behind, then yes.
Okay. Jazakallah.
I have one question.
Yes.
Like you said, when we draft a simple will with the executor's name and the name of the witnesses, who should be retaining that particular document, or let's say the signed original document, even if it's just a piece of paper, who should be retaining that?
It should be kept in a safe place, and your executor should know where it is.
Okay, so he should be accessible.
Yes. So in the event that you actually pass away, that your executor knows where that will is. So I just shared the BCMA's will kit inside the chat for those that would like to see it. So this was prepared by myself, and we had 2 lawyers on the team. So it contains a lot of the same information that I just mentioned to you. So it's not like a fill in the blanks, but there are a lot of clauses that you can include in your will if you would like. The reason it's not a fill in the blank template is because for legal reasons, our lawyers advised us against that. But it is still a very useful resource.
Jazakumullah khair.
Okay, so Jazakumullah khairan, everyone. And it was wonderful speaking to you this morning. And I hope everyone was able to benefit. So someone said they can't see the link. Is everyone else able to see the file that I shared?
Yeah, so I will also send this in the group, and also
Yes, of course. So if you can send it to the rest of the group, inshallah, that's good.
Yes, we'll do.
Okay, Jazakumullah khairan. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam wa rahmatullah.
Walaikum assalam.
Jazakumullah khairan for that beautiful Imam Yahya, and answering all of the questions. To the attendees, we are also working on a follow-up on this specific topic with a few lawyers. We'll keep you posted on that when it's ready, inshallah. Make dua for us. Yeah, that's about it. Subhanakallahumma bihamdik wa nashhadu an la ilaha illa ant wa nastaghfiruka wa natubu ilayk. Assalamu alaikum wa rahmatullah.